Good afternoon, ladies and gentlemen. Welcome to yet another segment of BW Legal World's Saturday Solutions, where we speak with experts on hot legal topics and latest legal developments. And today we are discussing the Insolvency and Bankruptcy Code, understanding the liability of the personal guarantor. Let's welcome our August panel for the day to take the discussion ahead. We have with us Kunal Tandon, Counsel, Delhi High Court and Supreme Court of India; Pooja Chakravarti, Partner, Argus Partners, Solicitors and Advocates; Mukesh Chand, Senior Counsel, Economic Laws Practice; and I'm your moderator for today, Kaustubh Mehta, Editorial Lead, hoping to get you as many insights as possible from our experts in the next hour. So experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms.
Thank you.
Let's dive right into the conversation with our panelists. Panelists, before we go to our Q&A round, could we have your preliminary views on the issue of personal guarantors and the Insolvency Bankruptcy Code? So, Mukesh ji, your thoughts, please.
Okay, thank you, Mr. Kaustubh. It's a pleasure to be on your channel for discussion on this important topic. It's a hot topic rather, on liability of personal guarantor. See, my view is that this liability of personal guarantor and law governing this liability is as old as the law of contract, not in the form of very formal statute law, but customary law, and the liability has been held to be coextensive with the principal debtor. Now, the IBC has not brought anything new. It has only codified the law which was existing in various statute and legislations. So if you go through the part chapter 3, you will find that all the major provisions are similar to the Provincial Insolvency Act and Insolvency Act, which was there earlier. And so far as liability of the guarantor is concerned, there is no change at all. He is liable, his liability is governed under Contract Act. And this provision is not a relief specific to anybody. This is a process where insolvency of the person is addressed. So it has to be seen from that point of view. It's not to be seen what the point of view of recovery or liability or right of the parties. It's a process. It's a process where you address insolvency. How you address it? It was there earlier also. Principle governing insolvency of personal guarantor or the individual is the same right from the beginning, from British era till now. There is no change in the concept and principle governing the liability of guarantor.
Thank you. Pooja, if you could give your insights.
See, the insolvency of guarantors, this area of insolvency law obviously has seen a lot of development, not only under IBC, but before also. Now, codifying it as a part of the Insolvency and Bankruptcy Code was much needed, and it is much welcome, because now the creditors can finally access the asset pool of the personal guarantors as well for faster resolution of debts. And the guarantors also, in the hopes of getting a discharge order as early as possible, would cooperate and make their assets available to the whole process. Now, only thing is that the law we see here is very meticulous, detailed, and process-driven. Now, the problems encountered by any process-driven law is that the impediments that arise are certain case specifics. So for this reason, for the law to be clarified and set in a certain way so that it is beneficial for all stakeholders concerned, it is a time-consuming process. So what we saw with IBC also, after 2016, it has been 6 years, and we cannot say that all areas of IBC are settled in a particular way. There have been amendments, there are precedents. So I am expecting that the law in respect of insolvency of personal guarantors would also see the same growth and development, would be different, would change, would be modified, would be amended, and there would be various precedents which would require to clarify certain aspects of it, and then only it would be a certain, specific, and beneficial to all concerned. Now, this is a problem with all process-driven laws. Also, one thing that we should not lose sight of is the particular logistics. For instance, the law provides that petitions should be filed before the DRT. But at the time this law was implemented, the DRTs did not really have the requisite infrastructure for this process. So there would be times where the DRTs and DRATs would not be functioning for months together. And there were even instances where the high courts would intervene and invoke their jurisdiction under Article 227 because the DRTs were not functioning. So logistical impediments like this would arise. We would have to hold it together and consolidate the law, build the infrastructure that is necessary, and move forward.
Thanks, Pooja. Kunal, your views?
Yeah, I think Mukesh ji and Pooja have already set the tone for our discussion. I would only like to say that in the opening that Ravi Kulkarni's judgment really put the law in perspective, where there was some confusion whether NCLT would take up matters relating to personal guarantors, or whether it would be only those personal guarantors whose corporate debtor is before NCLT and the CIRP has been initiated. So that cloud has been set to rest, where they have said that all personal guarantors, even in respect of corporate debtors, where CIRP is pending, in the sense that where Section 7 applications are pending, even corporate personal guarantors also will go before NCLT. So this aspect probably takes care of Pooja's last remark that DRTs are not functioning. So as far as personal guarantors are concerned, as of now, applications can be filed before NCLT. So those are my opening remarks, and I'm sure as we proceed in the seminar, we'll be able to deal with greater details of part.
Thank you, panelists, for your opening remarks, which were very insightful. Let's begin with our next segment, which is the descriptive questions. So my first question would be to you, Kunal. What was the position of personal guarantors prior to the 2019 rules?
Yeah, so I think as Mukesh ji had put it, we had something called Provincial Insolvency Act of 1920. To be very frank, when I got an invitation for this seminar, I started reading that act because I haven't done any case under the Provincial Insolvency Act of 1920. And probably because the popularity of that act was always in question as far as the creditors were concerned, the working of it. Let me give a slight background of that act. The act provides the power to the district courts to consider and recommend rehabilitation, repayment plans for insolvent people, individuals. And so basically it goes to the district court, which where the personal guarantor or the individual is residing or working for gain. So which means that all over India, we would have jurisdiction, probably, which led to multiple judgments and multiple conflicting views coming from various district courts and high courts. So that is point number one. As far as the procedure is concerned, the procedure more or less is the same as adopted under the Insolvency Bankruptcy Code. I think, in fact, at the end of the day, the procedure has to be same, because you go for insolvency and then you go for bankruptcy. In the insolvency, you are entitled to provide a repayment plan. The time periods may be different, but a repayment plan is to be adhered to. If repayment plan is not adhered to, then you go for bankruptcy, sell the assets of the individual and move on if there are any assets. There are restrictions put on the individuals for dealing with those properties, which is there under IBC also. The application under the Provincial Insolvency Act can be both voluntary and by creditors under Section 9. Act of insolvency has been defined under the Insolvency Act of 1920, which basically says that if you have intent to defeat the purposes of the creditors, defraud them, sell properties preferentially, etc., etc. So that is defined. And then Section 21 provides for attachment, reasonable security, production of books. There can be detention in civil prison. The vesting of the property always happens in the court, so you can't deal with those properties. So it's just like how we have here a moratorium, and then after that, how the procedure takes place. There is a bankruptcy trustee, etc. So it's a very similar kind of process which was going on. I think the reason why the Insolvency Act of 20 didn't work is because of the multiple forums that people had to approach. I mean, we have district courts all over the country, and probably governments thought that there has to be some kind of synchronization of personal guarantors with the corporate debtors and one forum looking at it. So probably that's why the Insolvency Act of 20 didn't pick up as we thought that it would. And in fact, I was reading a few judgments. Most of the judgments are also pre-partition. So that tells us that probably the act was never that popular amongst the creditors.
Thank you, Kunal. Pooja, how is the process of insolvency in case of personal guarantor kick-started?
Yes, so the process, as I said, is very detailed and it is meticulous. So when do you proceed to file any application against a personal guarantor, or a personal guarantor also can file an application before the adjudicating authority? 3 conditions need to be satisfied. If there is a personal guarantee, if it has been invoked, and amounts remain unpaid. Any other factor, the property of the personal guarantor or the stage at which the CIRP of the principal borrower is at, or whether it has started at all, are immaterial for this purpose. So at the outset, what happens is that the guarantor himself, who is the debtor, can file an application under Section 94 of the Act, either personally, or he may also do it through a resolution professional. Now, there is a Form A, which is in the prescribed format provided in the rules, and it is also very detailed. Now, there is a detailed list of documents also, which is supposed to be submitted with the form. Without going into the specifics, it generally pertains to the financial information of the guarantor, like the returns, etc., the assets of the guarantor, including something which is defined as the excluded assets under the Act. Excluded assets is again a defined term. It means the assets that the personal guarantor would be able to retain even if the RP or the bankruptcy trustee, as the case may be, takes control of all the assets of the personal guarantor for the purpose of the resolution or bankruptcy. Now, this Form A would be submitted with the relevant documents. You put in your financial details, details of assets, family members, your associates, details of the associates. Associates is again a defined term under the Act. And this is the way the application goes in for a personal guarantor when he chooses to file himself. Now, when a creditor files an application against a personal guarantor, there is this requirement of sending a demand notice to the guarantor. And if there is no response or payment within 14 days, then the creditor may also approach the adjudicating authority under Section 95 of the Act. Now, he would also specify the name of the RP in the application. And if the name is not specified, it will be suggested by the adjudicating authority from a panel which is available with them. Why this is particularly important in this case is because, unlike the corporate insolvency resolution process, the resolution professional here is appointed at the first instance. And after the appointment of the resolution professional, it is the resolution professional who goes through the application and ascertains whether he would like to recommend the personal guarantor for admission of the application or its rejection. He would file a report to this effect. Now, once he has filed a report, of course, the personal guarantor procedurally, though it's not particularly provided, but is generally is allowed to file a reply or deal with the contents of the report. But it is noteworthy that until this stage, the personal guarantor does not really have a say, which is also the reason that the constitutional validity of these sections have been challenged in a writ petition before the Supreme Court, which is currently pending. So after the RP has ascertained and filed a report, the adjudicating authority will consider the contents of the report and finally come to a conclusion as to where the application should be admitted or not. After the admission of the application, of course, the process of preparing the repayment plan is followed, which is, of course, extremely detailed as provided in the Act. So the RP would call the creditors meeting if he deems necessary. He would assist and guide the debtor to prepare the repayment plan that would be finalized and placed before the adjudicating authority. And so the process continues.
Thank you, Pooja. I think Kunal and Pooja have set the stage for the discussion to move ahead. Mukesh ji, yes. So my next question is to Mukesh Chand. What is the process for rehabilitation of or repayment plan of a personal guarantor?
Before I come to that question, as I said in the beginning, see, so lot being said about the law under IBC. See, I said the IBC in chapter 3 does not establish the liability of the guarantor. That is governed by the Contract Act and Contract of Guarantee. These are the only two documents based on which liability of the guarantor is settled, arise and settled. So IBC is only a procedural aspect of governing insolvency. It provides one of the ways to address insolvency. Liability, the creditor has right to recover dues from the principal as well as guarantor. And as creditors can file application at the DRT, or if they have got security, they can enforce this under SURFACI Act. And if they choose that insolvency is the better route to address this aspect of it, so they can file applications. So there are various options available. This is not the one of the option, and does not IBC, as is made out to be many scholars and people, that it's a new law. Law is to be settled. Law is already settled right from the days of Privy Council, and there is no change in the law of governing liability of the guarantor. It's only prescribed procedure, and as Mr. Kunal said, there is nothing new in the procedure. It is already this almost identical to the procedure prescribed under Provincial Insolvency Act or Insolvency Act, barring certain minor adjustment here and there and the procedural aspect of it. So, there should not be any confusion as regards that law is prescribed under IBC. The law is not prescribed under IBC. Law is governed by the Contract Act and Contract of Guarantee. Now, coming back to what I forgot your question.
What is the process it happens?
Now, because I have a lot of experience from the point of view of creditor, so I'll try to explain it from the both side point of view. That now, if the application is admitted, as Pooja explained, that there is a detailed procedure to be followed for admission of the guarantee. This is one way I can add that. The one way the personal insolvency procedure is better than CRP is that RP gets, there is initial scrutiny of the entire application, and there is a report to be submitted by RP on admission or rejection of the application, and the NCLT takes view based on this report. So one way this process is better. So if the settlement takes place during that process, first stage process, the party can settle or repayment, they can arrive at any settlement, or things may get settled. So RP will submit report accordingly. So things will not move to the second stage where the admission occurs. But in the eventuality, if nothing happens during the first stage and RP submits a report recommending admission of the application, then application get admitted. by an order of the court, NCLT, and or adjudicating authority. Now, see, with that recommendation, RP also submits a proposal for calling for meeting of the creditor because claims have already been filed. So he also submits recommendation and prescribed date for meeting of creditor. Now, in that meeting, the debtor is supposed to submit a repayment plan. It's not a resolution plan, it's a repayment plan, and only debtor is entitled to submit repayment plan because it's his own liability. So he submits a repayment plan, which is submitted before the creditor. Now, one more thing I'll add here is that, see, since it is a procedural aspect, part of insolvency, secured creditor who have not forfeit their right to enforce security, they and unsecured creditor only part of this process, second stage process of repayment plan, considering repayment plan. Secured creditors who have not forfeited their right to enforce security during insolvency process, they are outside this process. So they can take their own steps as regards security. And it's only when they relinquish or forfeit their right to enforce security, they become part of this repayment plan. So basically, conceptually, this repayment plan process only covers unsecured claim and secured creditor. And one more critical thing is that even if the debtor prescribes or proposes anything as regards security of secured creditor who is not part of this process, his consent will be critical. Creditor's consent will be critical for this proposal, which deals with his securities. So the repayment plan as submitted by the debtor is considered and voted upon by the creditor as under CRP, normal CRP, if it is approved, and if it by the requisite vote, then RP will submit report accordingly. And the plan, if the plan gets approved, then the implement stage starts there. So the critical thing will be like for creditor, say the whether to forfeit their right to enforce their security during this process or not. That is the most critical thing for the creditor. Because see, there is a, I can share with you, there is a very critical issue, like, so lot will depend who is controlling the voting share of the committee, the overall committee. So they get their say. So if I have relinquished my security and by voting majority vote, 66% of vote, the plan gets approved, which is not to my liking, but I am bound by that resolution plan. So it's a very critical thing. So secured creditor will have to take a very calculated decision to forfeit their right to enforce security or not. And the debtor also has equal right to present any voting share. Obviously, these repayment plan will be viewed by the creditor in the light of the net worth of the guarantor and whatever security or and assets he is having, overall net worth of the guarantor, and which is should be supported by independent documents and certified by the independent chartered accountant and other similar, and income tax returns, GST returns, all these supporting documents is to be there, because the creditor have to be convinced that this is the only net worth, and based on that only you will have to settle the issues. And it is in the interest of creditor also as well as debtor that things get settled, and otherwise the thing will go to bankruptcy stage. If the plan gets rejected, if it is not implemented, if there is default in implementation, the creditor or the debtor himself, they can move to bankruptcy stage. As I said in the beginning, this is the relief neutral process. See, relief, see, it's a good, some of the cases it may work in favor of the debtor also to file application for bankruptcy, because once he completes the process, first stage or in eventuality where bankruptcy is initiated, once he is a discharged bankrupt, if bankrupt is discharged, he is a free person. he can enter into any sort of contract. So those disqualifications which occur when bankruptcy process starts, those are taken care of by order of discharge. So it's a very relief neutral process. It can work for both sides.
Thank you, Mukesh, for the elaborate answer. Let's circle back to Kunal. Kunal, I'd like to ask you the priority of payments between creditors in the event of bankruptcy of a personal guarantor.
Yeah, so I think here I must draw some parallels between the process for corporate debtors and process involved for personal guarantors. If you really see the process for corporate debtors, the first portion of it is the corporate insolvency resolution process. In the case of personal guarantors or individuals, it is the process of insolvency. And the second process of liquidation in respect of corporate debtors is like the process of bankruptcy for individuals. So that's the parallel between corporate debtors and individuals. So it's more or less identical, except a few steps here and there. Like as Pooja said, the difference between section 94, 95 step leading to section 100 step. So that's the difference, that interim moratorium in individuals happen right on the first day, as against corporate debtor, that interim moratorium only happens when an order of CIRP is passed. So those are small nitty-gritties where the changes exist between the two kinds or nature of entities. As far as the priority of payments are concerned, I don't see much difference between the priority of payments. For example, in corporate debtor section 53, we have the cost and expenses of the liquidation process, which has to be paid first. Over here, it is the cost and expenses incurred by the trustee for the bankruptcy process, which has to be paid in full upfront. Second is the workman dues for 24 months, along with debts owed to secured creditors. So that's also same as 53(1)(b), which is there. Third is, and this is where slight difference is, that wages and unpaid dues owed to employees other than the workmen for 12-month period have to be paid at the third level. Fourth is the amounts of the central government and state government for a period of 2 years. And last is the all other debts and dues owed, including unsecured debt. So that's the waterfall mechanism provided in section 178, which is under part 3 of the Insolvency Bankruptcy Code. Section 123 also allows the creditor to either relinquish or not relinquish the mortgaged properties, which is the right available under 52 in respect of corporate debtors. So that's the priority of payment between creditors for personal guarantors.
Thank you so much, Kunal. Let's move again to Pooja. Pooja, if you could explain the coextensive nature of the liability of the guarantor as per section 128 of the Indian Contract Act.
So the Indian Contract Act section 128 provides that liability is joint and several for the principal borrower and the personal guarantor, subject to any agreement. So how does it translate to IBC? It means that you can initiate an action against the corporate debtor, only the corporate debtor, only the personal guarantor, both of them, or just one of them, without initiating a process against the other. Now, much water has flown under the bridge in this respect, and we all know that the famous Piramal judgment had held otherwise, which view was again reversed by the Athena Energy, where the court admitted applications for simultaneous CIRP of a corporate debtor as well as a corporate guarantor. Now, this is what is the coextensive liability in a nutshell is, and but we can also see the effect of this coextensive liability in other aspects of the process. For instance, if you take the issue of limitation, how it operates via section 128 in the process of IBC, that would be very interesting to observe. We all know that an acknowledgement by a borrower would have the effect of extending the limitation period under section 18 of the Limitation Act. Now, the Supreme Court has held that if a principal borrower has issued such an acknowledgement, it would apply and for a personal guarantor as well. And the period of limitation to initiate an action against the personal borrower would also stand extended, notwithstanding the fact that the personal guarantor has not acknowledged the debt at that point. So there are some more interesting judgments. For instance, the issue of a recovery certificate by a DRT, for instance. So we know that it also has the effect for extending the limitation period for filing of a Section 7 under the code. So the courts have held, I think the NCLAT has laid down the law in this regard and held that this will also have the effect of extending the limitation period for proceeding against a personal guarantor. So these are some interesting aspects where this joint and several liability plays out. Another interesting case that I remember is which has settled the question of Section 10A under the IBC. Now, Section 10A provides that for corporate debtors, if the default is between 25th March 2020 or such a date extending to 1 year, you cannot proceed against the corporate debtor because that default will not be considered for initiating a CIRP action. However, it has been laid down by the NCLAT that since the section does not refer to personal guarantors, in considering the same default, you can in fact initiate an action against the personal guarantor, even if an action against the principal borrower company is barred. So these are some of the nuances and how Section 128 of the Contract Act has played vis-a-vis the various provisions of the IBC.
Thanks a lot, Pooja. Let's circle back to Mr. Mukesh. Mukesh ji, what is a personal guarantor's right of subrogation? If you could throw some light on the overriding powers of the code under Section 238.
See, this is another topic where a lot of controversy is being created. It's a lot of theories are going around on this aspect also. See, right of subrogation of the guarantor, it's recognized under Section 140 of Contract Act. Now, so the most critical aspect of it, it's a well recognized right, and no, there cannot be any denial of that. But if you see the provisions of that Section 140, it says where the surety has discharged the obligation. The first critical aspect is that the guarantor should have discharged. This right is available only when he discharges his obligation. Then only he will step in the shoes of creditor, and he will have similar right what were available to the creditor as against the principal borrower. Now, the one more critical aspect of it is that he will have right to all the securities which were available to the creditor as against the principal debtor. Now, this is the law and which governs right of subrogation of guarantor. Now, but most of the people are forgetting whenever they say that this right is taken away from the guarantor. Now, this right will be available to him. He cannot claim this right upfront, that I should have a right to subrogation subsequently. Now, you make the payment first, you discharge your obligation first, then only you will have a right. Now, another thing is that it's not a perpetual right that which should be available to you, and it is not a right which is guaranteed by creditor. It's provided under the Contract Act, and it's not a perpetual right. It's not infinite right that it will be available to you. And so it will depend. So whenever right occurs to you, when you discharge the obligation, you get this right. Now your subrogation right will depend on the status of the corporate debtor, the principal borrower. Now, suppose in case of hypothetical situation where individual dies, principal borrower is individual, he dies. By the time the guarantor discharges duty, his right is gone. A similar way under IBC, see now it's the after resolution plan is executed, that is the law of the land, that the corporate debtor starts on a clean slate. All liability are discharged, which are governed under resolution plan or not filed. Or so now if the company goes under liquidation, there also the right goes, because the company is dying now. Company is in the process of being eliminated from the record, and here the person is reborn under CRP. Person is reborn. So if you wait, you are carrying a risk. If you are waiting that everything should get settled, then only I'll pay. You are carrying a risk of change circumstances. Change circumstances in the IBCs are two circumstances. The person is reborn, the old, everything is washed off. And second is person is going to be criminated, their final rights being fraud at the stage of liquidation. So there you have chosen to wait, and your circumstances have changed beyond your control. And one more thing, see, another confusion is there, that creditor take a call for settle the dues. See, conceptually, and now the Supreme Court has also upheld in SR case. See, this settlement happens not because of creditor. It happens because of operational law. The law says the committee of creditor decide. There is a mechanism put in place that creditor decides on the viability and feasibility of the resolution plan. They approve it. So, and which is ultimately approved by the court as per the provisions of law. So this discharge happens because of operational law, not account of free will of the creditor, individual creditor. The creditor it's a expert body, because banker happens to be there, so they draw an analogy, you are sitting there. Conceptually, it's a body of expert who can also take financial risk, providing additional finance to the creditor to make it more viable. So this was the as regards subrogation. So if a party waits, wait for the circumstances to change, and circumstances change beyond a situation where he will not have any recourse available to him, it's a right does not survive, and he will not have any right to subrogation under any of those situations which happens under IBC.
Thank you, Mukesh. Let's circle back to Kunal. Kunal, when does a personal guarantor's liability extinguish?
Yeah, so it's a question which can be answered very easily in respect of the insolvency process. However, at the bankruptcy level, I think it is not a very easy question to answer. Of course, at insolvency level, once the repayment plan is presented and that payment is made, it's all done and gone, because under 117, 118, if payment is made as per the plan, then he's discharged. Of course, consequences of that discharge, each act and enactment will have its own consequences. As far as the bankruptcy process is concerned, it's really at the at section 178 level where waterfall mechanism is provided, where ultimately the personal guarantor is discharged. But the question at the end of the day is that waterfall mechanism may not provide the entire payment to the creditors who are there. So what happens? IBC is silent on that. Of course, like we all do in corporate insolvency resolution processes and the liquidation process, that once 53 happens, when payment is made, it's all over. I think over here also it's all over. But there could be issues relating to preferential transactions. There could be issues relating to fraudulent transactions. There could be issues relating to overvalued, undervalued transactions, etc., etc. So if one really comes to bankruptcy process, I think that process really depends on a case-to-case basis as to at what level will it get over. So I think my take on that would be that.
Thank you, Kunal. Pooja, my question to you would be, are assets of the personal guarantor protected by the moratorium?
This is actually has been squarely answered in the statute itself. You're talking about the section 14 moratorium, then the subsection 1 would not really extend to sureties. Now, this was not such a settled position all along. There were conflicting views, and in the early days of IBC, of course, we would see where a moratorium was operating in respect of the assets of a corporate debtor. The personal guarantors would run around saying that they were also protected within the purview of the order, and then seek orders of stay in all courts in proceeding against them, including 138 proceedings under the Negotiable Instruments Act before the criminal courts. But we have moved on from there. And in fact, there are also a few NCLAT decisions in those times which pertain to this, and they hold that the guarantor's assets are also protected if there is a moratorium for the corporate debtor. But thankfully, we have moved on from there, and now the statute is squarely covers the issue. And there are also judgments on the precedents that we can look for. Now, the chief contention, the chief logic behind this thing is that if we cannot proceed against the guarantor's assets also in case the borrower's assets are protected by a section 14 moratorium, then there is no point of having this separate chapter under the Insolvency and Bankruptcy Code for resolution of debts of the personal guarantors. Also, if that is the position of law, that would have been the position of law, then the entire object and purpose of section 128 of the Indian Contract Act would have been defeated squarely. So I remember a particular judgment of the Supreme Court, I think SBI versus Ramakrishna, where this issue was argued at length, and the arguments from both sides were considered by the court, and then the court arrived at a decision which has been upheld by Lalit Jain as well. So here what had happened is the corporate debtor had filed a section 10, and the section 10 had been admitted, and of course a moratorium was in effect. Now the personal guarantors, they turned up and said that they were squarely covered by the moratorium also, and no proceedings could be filed against them. Now here the court actually went into the different chapters pertaining to CIRP and the insolvency of personal guarantors and compared the moratorium provisions and said the fact that the personal guarantor's insolvency contemplates a different moratorium, though those sections were not notified at that time when the judgment was delivered. So it could not have been the intention of the legislature that the assets of the personal guarantors would also be covered under the moratorium of under section 14 for the principal borrower. So the court also relied on the ILC reports for this, and then came to a conclusion that definitely this moratorium would not cover the guarantor's assets.
Thank you, Pooja. Mukeshji, does NCLT have the power to direct liquidation of the assets of a personal guarantor?
As I said, it's a insolvency of personal guarantor is a primarily three-stage process. First is where application filed and the RP submits a report. Second is when NCLT or adjudicating authority consider that report and take decision on admission, then insolvency process, and then bankruptcy process. So till the insolvency process is going on, there is no question of enforcement of any security of the creditor, which have relinquished their, they have forfeited their right to enforce security during insolvency process. So if the repayment plan is accepted, the payment happens as per the repayment plan. But it's only the question of liquidation or realization of state of bankrupt or insolvent happens at the stage of bankruptcy, where all the assets of the debtor gets vested in the bankruptcy trustee. The insolvency professional acts as a bankruptcy trustee at the bankruptcy stage. So all the assets gets vested in the bankruptcy trustee at the stage of bankruptcy, and he realizes all those assets, and then the proceed is distributed as per the priority of the claimants and creditor. So we cannot say that NCLT has a right to liquidate or not liquidate. It's the process-driven thing where it happens automatically. So if the bankruptcy is initiated, then obviously the process gets initiated for realization of assets of the debtor. But there is a provision that even that order can be revoked if there is subsequently any development happens where the creditor accepts any proposal. So there's a very flexible mechanism under IBC, both at CRP stage and even under insolvency stage. So a lot of flexibility has been built in. So one more thing I would like to add that, see, even where this notification was not there, November 15th, 2019 notification was not there, bringing in for the provisions of the code for personal insolvency or corporate debtor. These provisions of Provincial Insolvency Act were very much in force, and they are still in force as regards other guarantor. It is another misconception that those provisions have been repealed. See, 1511 notification has only brought limited provisions of IBC as regards personal guarantor to corporate debtor. For other individual bank insolvent, the provisions of Insolvency Act and Provincial Insolvency Act are still in vogue. So even prior to that notification, creditor had right to file insolvency application under those enactment. So whether it was available under IBC or that is immaterial. So those provisions are now been shifted to IBC. So there is, so if you see the recourse from the point of view of recourse, those recourse were still available earlier also, they are available now also. There is no change. Only the limited aspect of it has been shifted to IBC.
Thank you, Mukesh. Let's circle back to Kunal. Kunal, which assets of personal guarantor are included in the insolvency proceedings?
Yeah, so there is a definition of excluded assets provided under section 79, subsection 14 of the code. That gives details of all the assets which are excluded. So, for example, let me read it from the section itself. Unencumbered tools, books, vehicles, and other equipments as are necessary to debtor or bankrupt for his personal use or for the purposes of his employment, business, or vocation. Unencumbered furniture, household equipment, provisions as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. Unencumbered personal ornaments up to rupees 1 lakh of the debtor or his immediate family, which cannot be parted with in accordance with religious usage. Any unencumbered life insurance, pension plan taken in the name of debtor or his immediate family. An unencumbered single dwelling unit owned by the debtor of rupees 10 lakhs in rural areas and 20 lakhs in urban areas. So this is the definition which is there. So in a way, it is basically those assets where which are of personal use and are required for sustenance of the debtor. Second aspect of this is that there are certain transactions which automatically become included in the assets covered under part 3. Few of them are like, for example, if there's a transaction of sale of a property between the date of filing of bankruptcy application until the bankruptcy commencement date, that will be void, even if it is done in good faith, etc. Then the bankruptcy trustee may also disclaim any unprofitable contract or any property which is unsellable or not readily sellable. So they can approach NCLT for these purposes. And of course, then there are sections relating to the undervalued transaction, preferential transactions, exorbitant payments, fraud, etc. So these are the two parts of the excluded assets.
Thank you, Kunal.
If you may add, see what there is one more interesting feature of personal insolvency is that, see, unlike CRP, under personal insolvency, these avoidance transaction can be looked back only at the stage of bankruptcy. See, no, it can be the process does not get initiated at the admission of the application. It only gets initiated at the stage of bankruptcy. So there is more easier process for insolvent person.
Right. So let's take the discussion ahead. Pooja, which liabilities of personal guarantor cannot be discharged under repayment plan or discharge order under bankruptcy process?
So for this, a little bit of background into the difference between discharge under a repayment plan and a discharge under a bankruptcy process. Now, they are covered by different provisions of the IBC. So as far as the discharge under a repayment plan is concerned, when a repayment plan has been fully implemented, or let's say is in the process of being implemented, the RP can file an application for discharge of the debtor. The debtor will be discharged, but the implementation of the repayment plan may continue. Now, as far as the discharge and after the repayment plan is concerned, in case of insolvency, it will pertain to the debts that are covered only in the repayment plan itself. But when we are talking about bankruptcy, of course, we must remember that bankruptcy here does not follow automatically. It is an option that the creditors exercise. So in case there is the petition itself has been rejected or the repayment plan closes early, there is always an option available to the creditors to file a bankruptcy petition, unlike the CIRP process, where liquidation follows as a matter of course. So in case where a bankruptcy petition has been filed, a bankruptcy trustee has been appointed and he has taken control of the assets and he has carried out administration of the asset, and finally he's applying for a discharge. The difference with the discharge in respect of a repayment plan would be that this actually encompasses all debts covered in bankruptcy, subject to certain exceptions. And one exception is the excluded debt. Now, excluded debt is a defined term under the Act, and the section prescribes what an excluded debt is. Now, it has to be mentioned here that a petition under the provisions of insolvency also cannot be filed in respect of an excluded debt. These excluded debt are outside the purview of the entire proceeding. So these are actually a liability to pay fine that has been imposed by a court or tribunal, or any liability to pay damages for negligence or breach of statutory, contractual, or any legal obligation, or if the personal guarantor is paying maintenance to any person under any personal law or maybe the Domestic Violence Act, then this would be an excluded debt which would not come under the purview of the discharge after bankruptcy. Or also, I'm sorry, also a student loan, which is detailed in the section.
Thank you, Pooja. Let's circle back to Mr. Mukesh. Mr. Mukesh, how has the Supreme Court left personal guarantors in a difficult situation after the Lalit Kumar decision, whereby creditors have been empowered without providing any right to the personal guarantor?
No, I don't agree with that view. See, liability wise, there is no change. It's the only question of procedural aspect of it, that whether the creditor can proceed under IBC as regards the guarantor. As I said in the beginning also, see, otherwise also creditor had right and option to proceed. Even if IBC was not there, creditor had option to file under Provincial Insolvency Act or Insolvency Act, whichever act was applicable. So the right to initiate insolvency was available to creditor earlier also, only because now the IBC is in limelight because of the time frame provided under the code as well as the stringent provisions. So this issue has got highlighted. So judgment has only clarified the legal position that since the liability of the guarantor is coextensive with the principal borrower, so if the guarantor fails to discharge his obligation, the right is available to the creditor. It is also available to the debtor. See, it's not that only creditor can move under IBC. Creditor, where the debtor feels that he has no means to file and he's now bankrupt or insolvent, he can himself go and file application of under IBC, and that procedure is follow. He may get discharged ultimately. So it's as I said, it's a very neutral process, relief neutral process. It's available to both the parties. So, and it was available earlier also to both the parties. It's only that now the issue has got highlighted because see, there is a CRP happening or may not be happening now, since Supreme Court has clarified that the creditor need not wait for admission of the application against CRP. They can proceed against guarantor under IBC without initiating insolvency process for the corporate debtor. So law-wise there is no change. It was as it is. It is now remains as it is now also. So it's only a question of certain issues like subrogation or these issues which are being agitated now as regards liability of guarantor. But I don't agree that the Supreme Court judgment has disturbed anything. It's rather just only clarified the issue as regard that you have recourse and you can proceed. Since the law, the legislature has put the provisions into force, so now obviously those will be proceeded with. So as I said, it's not debtor himself can also take advantage of these provisions. He is not doing anything. If he has no resources to repay, no assets to do the discharge the liability, he can file for insolvency.
Thank you so much. I'd like to take every panelist's closing comments on the issue and how they think about the law ahead. So Kunal, I'll start with you. What do you think about the future of this particular issue, how it will evolve, and what are your expectations?
My expectation as a lawyer, I think, are very different. I don't think I should be discussing it here. But I do feel, as I opened, that the momentum that we had built up on the corporate debtor side, on the corporate person's resolution process, and the momentum which is still there in respect of the corporate person, at least I haven't seen the same momentum in respect of the personal guarantors. There could be various reasons for it. It could be that DRT has not yet started taking up cases in respect of individuals and partnership firms. It could be the convoluted process which is involved in Part 3, or it could be the overburdened NCLTs in India. It could be anything. Whether it leads to resolution of debts of the creditors under Part 3 or not, that I'm yet to see. I haven't reached a stage in any matter where I can say that, yes, I've achieved it when appearing for a creditor. So I think for me to say that it has failed, it's too early. For me to say that the momentum has not picked up, yes, it hasn't picked up, but there could be various reasons. The intent of the law, I think, is good. It brings together the law in one forum, the forum which understands the law best. And I think this will be a good law to go ahead with. At this stage, I think I'll leave it at that.
Thank you, Kunal. Pooja, your closing comments?
Well, I would also not I would agree with Kunal on this. This is basically, according to me, a waiting game. So we still have to go a long way to see what are the difficulties, the impediments that we encounter, since it is as I mentioned, a very process-driven statute. So only when the matters progress and particular stages arrive can we particularly see what impediments and difficulties we are encountering logistically, practically, and only then they can be dealt with at that appropriate stage. And just like IBC, there are also challenges in the process, and the challenges have started. Like I mentioned, that there is a writ petition pending on the constitutional validity of certain sections. So yes, we need to see how this pans out. As Kunal mentioned, the intent is good, the content is good, but let's see how far it takes us.
Thanks, Pooja. Mr. Mukesh, what are your views on the way ahead?
As I said, there was not much of awareness about the process among the creditor, among the debtors, and among the practitioners also. So, see, I know from my experience about a particular bank, more than 1,000 applications have been filed, and that may be a situation in respect to other banks also. It's only that a process is taking time because NCLT is already overburdened, and there was also some confusion among the NCLT and the practitioner that whether such type of application for insolvency of personal guarantor can be initiated without initiation and admission of application against the corporate debtor. So it took some time, and before the thing got settled by a State Bank of India judgment, where the Supreme Court has clarified that this insolvency can be initiated and can be filed without initiation of insolvency against the corporate debtor. Now, the people are trying to adjust and understand, but so far as my experience goes, see, it is in the interest of both creditor and debtor to settle this issue of the guarantee that he gets discharged or the liability gets paid. There is no point in prolonging the matter in DRT or any other civil court for 10 years, 15 years. Creditor will wait for 10 years. There is no point if they know that these are the only assets which can be realized. So better to finish it off in the time-bound process under IBC because the maximum time which is provided is 1 year. So it works in interest of both the parties. You either settle for debtor, you either settle it before insolvency is initiated, or if you want that insolvency process to go on, then get it settled under IBC and you start fresh after the liability is discharged, whatever way, whatever percentage way. For creditor, it works that 2 years. You need not wait for 10 years to close the chapter. You have recovered whatever amount was to be recovered against the corporate debtor under the CRP. Now, the balance amount, if any, can be recovered or to whatever extent as per the net worth of the guarantor can be recovered. You recover it and close the chapter under IBC. There is no point in keeping the account in your books for such a 10, 15 years and without any result. See, after 10 years, if you keep on proceeding, if assets are there, you'll be able to recover it in 5 years' time maximum under SFSC or DRTI. But if nothing is there, say if net worth is not there, what will do while keeping the proceedings pending for 10 years, 15 years? You are only wasting your time, wasting court's time, and wasting executive time and resources on this debt type of the case where you don't have any chance of recovery. Only for the purpose of theory and records you are initiating. Now, for me, that what I have been advocating to both the parties, to even creditor, which say resulted in lot of filing of these cases, that it's a package. It gives you IBC gives you complete solution for a account. Now under CRP, corporate debtors liability settled. Now under IBC for personal insolvency, it gets settled. So the entire liability is resolved. You move on. Whatever amount was recoverable, you have recovered. Now you move on. The company will start afresh, and then the guarantor will start afresh. So, and bank obviously, he can utilize that money in another more profitable investment or lending. So it's a complete package and it works for both the parties. There's no point in wasting time and resources on fighting out cases and then, but ultimately which does not bring you any result. So get it settled, file if it works, file it. If you have security as a creditor, you recover it under SARFAESI Act or DRT Act, but close the chapter. Under IBC, still assets of the guarantor can be sold and the amount utilized for recovery. So either way, you get, I think it's IBC is a better package as regards other recovery proceedings. You stand better chances of closure of the issue and recovery. And see, the time value of money is the time-tested formula for any recovery. See, if you recover 1,000 rupees after 10 years, recovering same 1,000 rupees is day one, today or 1 year, it's much more valuable than recovering 1,000 rupees after 10 years. So if you multiply those 1,000 over 10 years, that recovery will be crores, hundreds of crore rupees. So that is my assessment of the issue. Thank you.
Thank you so much, panelists, for the valuable insights. It has been a comprehensive discussion. Take care and have a happy weekend.
Thank you.
Thank you so much.
Thank you, everybody.
And thank you, Pooja. It was a nice discussion.
Thank you. Thank you so much.
Thank you.